Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, I do read the comment sections of the videos a lot, and one of the most common questions that we've been getting lately is, hey, what the hell is going on with Washington's assault weapon ban and all the court cases that challenge it? Today, we are going to get you up to speed on that. But as you know, for those of you who regularly geek out on this channel, we've been following a lot of other crazy cases around the country and seeing a lot of even crazier rulings coming out of judges who are hell-bent on civilian disarmament, even to the point now where they're getting very creative in their interpretation of history, and they're even coming up with all new legal theories, the ones that we had never heard. Circle back now to Washington's last stand as far as trying to get an injunction on its assault weapon ban. There is a huge argument at play. We're going to go through the response pleadings from the plaintiffs here because there's a huge issue in here, and not only does it affect everybody here for the hometown crowd, it's going to affect everybody around the country because this is one of the next big arguments that has to be tackled. So today, let's spend a few minutes and let's talk about Washington's last stand to stop its assault weapon ban and why it matters to all of you. Okay, so the case we're talking about today is Banta v. Ferguson. That is the case that is filed in the United States District Court in Eastern Washington. Now, to give you an instant replay, we started with Guardian Arms versus Inslee, the one case that was filed in state court, originally filed in Grant County, punted to Thurston County, and ended in much this fashion as it related to the motion for injunction. Then, of course, we got to Hartford v. Ferguson, the case filed in the United States District Court for Western Washington, where the judge there absolutely drafted one of the most horrific rulings you will ever see and really did carve out some new rules of law, ones that we were not aware of here at Washington Gun Law, and in geeking out on a lot of the other channels, appears none of them were familiar with it either. Now, when it comes to outright bans on weapons, for those of you who geek out on this channel or any other channel, you know it all comes down to the common use test. And the common use test is a very simple test, which means that there is only a historical tradition in this country in banning firearms which are both dangerous and unusual. Now, when we talk about the most modern platform of sporting rifle in circulation, when we talk about the standard capacity magazines that are in common circulation, there is nothing unusual about any of them, and that is why these bans are per se unconstitutional. Now, if any of these courts that are hell-bent on civilian disarmament actually applied the common use test as announced by the United States Supreme Court, not so much in Bruin, but in Heller, very definitively affirmed in Bruin, but enunciated by Justice Scalia in Heller. Now, if they followed the rule of law, well, then, of course, they don't get the result they want. So what have they come up with? Oh, it's a whole new test called in common use for self-defense. And essentially what they're saying is that when we take a look at the statistics of how frequently semi-automatic rifles are used in self-defense situations, lawful self-defense situations, we see that it happens so very infrequently that, in fact, they are not in common use for self-defense, and therefore government may ban them. Now, interestingly, Plaintiff's counsel says, well, if we do the reverse and figure out, well, if there's millions and millions of these, and there's debate whether there is 6 or 8 million from the state of Washington here, and candidly, it's much more. But what counsel pointed out is if you take a look at the number of semi-automatic rifles that are used in mass shootings and compare that to the number of weapons that the government admits is probably owned, what you're looking at is that there is a lawful ownership rate of these firearms of 99.999975%, okay? Now, how does plaintiff's counsel, and you know, I've spoken highly of plaintiff's counsel on this particular case in Banta. I think this case is in really, really good hands. The pleadings so far have been dynamite, and this is no exception. I want to share with you some of the pleadings so you get a better understanding of what are we combating here with this in common use for self-defense. Now, this is how plaintiff's counsel counters this argument. Whatever else may be said of the firearms House Bill 1240 bans, they plainly satisfy Bruin's broad definition of arms, so the right to keep and bear them is presumptively protected by the Second Amendment. And the historical inquiry here is equally straightforward. Bruin teaches that our nation's historical tradition is to protect the right to keep and bear arms that are in common use today, which the Firearms House Bill 1240 bans, plainly, indeed, indisputably are. And you see, they're having to make this argument because what the state of Washington, and this is not unique, we're seeing this toxic argument pop up everywhere, is that if the firearm is not in common use for self-defense, then the plain text of the Second Amendment doesn't even cover that firearm. Plaintiff's counsel counters that argument with, that is the end of the analysis, for a state may not flatly ban what the Constitution protects. Washington resists that conclusion only by distorting Bruin beyond recognition. And of course, whenever the simple, straightforward argument works against your side, what you need to do is muddy the waters. And that's exactly what the state of Washington is trying to do here with this new in common use for self-defense. Plaintiff's counsel brings everyone back to reality as follows. Under Bruin, then, the threshold inquiry here is simple. Not even the state disputes that the myriad of rifles, pistols, and shotguns HB 1240 bans facilitate armed self-defense or are things that a man wears for his defense or takes into his hands or useth in wrath to cast or strike another. Nor could it. The firearms HB 1240 bans satisfies the textual definition of arms. The Supreme Court has already decided what arms a state may ban consistent with our nation's historical tradition of firearms regulation, arms that are highly unusual in society at large, not in common use today. And where this in common use for self-defense comes from is from an absolute gross misinterpretation, basically a half-truth that comes from Heller, because Heller clearly says that the Second Amendment protects all firearms that are in common use for all lawful purposes, including self-defense, okay? And what they're saying is that the only lawful purpose is self-defense. And if you're not possessing it for self-defense, well, then the Second Amendment does not even cover it. But that is not the test, as plaintiffs put it. The question then is whether the arms HB 1240 bans are in common use for lawful purposes. And once again, the answer is easy, as the arms HB 1240 bans are the furthest thing from highly unusual in modern America. And to get you an idea of how convoluted and disingenuous this argument is from the state, this is how plaintiff's counsel summarizes. Accordingly to the state, whether firearms are commonly possessed is irrelevant. All that matters, says the state, is how frequently people use, by which the state seems to mean fire, them in self-defense situations. That is a remarkable claim, given that the Supreme Court has declared that the frequency of possession, not the firing, let alone firing in an actual confrontation, dictates whether a firearm is in common use. That's right. It is the mere possession and ownership of the firearm that dictates whether or not it's in common use. It is not how frequently that firearm is used for any purpose, including lawful self-defense. Or as plaintiff's counsel put it, indeed, Heller held explicitly that the only arms that may be banned consistent with historical traditions are those not typically possessed by law-abiding citizens for lawful purposes. And to further pick apart this very toxic argument, plaintiff's counsel points out how frequently law-abiding citizens keep versus carry handguns or fire them at ranges versus at attackers is therefore legally irrelevant, as an individual lawfully uses her firearm every time she does any of those things. The state's contrary argument is not so much an effort to apply Bruin as it is to rewrite it. And they go on to further point out, what that means here is simple. Given that 6 to 8 million Americans lawfully possess at least one AR platform rifle, the state bears the burden of showing that the typical member of this enormous population does not, in fact, keep such arms inside their home or carry it outside their home for lawful purposes like self-defense, but instead typically keeps and carries such arms for unlawful ends. The state has not even tried to do so. And I actually misspoke earlier, because if you want to know what the real number is, if you take the total number of suspected AR owners and you then subtract from it the number of people who have used it for unlawful purposes, what you're left with then in the total population of AR owners who are lawful is the remaining 99.999995%. So as you can see, plaintiff's counsel has done an amazingly good job here of taking this ridiculous argument of in common use for self-defense and really shreds it and talks about just what an disingenuous and ridiculous argument really is. The case, once again, is Banta v. Ferguson. It's a case out here in Washington State. It's the last of our 3 cases to try to get an injunction on our assault weapon ban. However, everyone around the country needs to carefully watch this, because this in common use for self-defense argument, I can assure you, is going to pop up in state after state after state. And this is the proper way of attacking it. The case, once again, is Banta v. Ferguson. We will put links for all of that down below for my hometown crowd. That is what is happening right now with the one last remaining case we have. If you have any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.